This is a right of reply. This is a joint statement of the Civil Society Organizations Reference Group, an Interreligious Council of Kenya, and the National Council of NGOs, that's the NGO Council, on the proposed amendments to the Public Benefits Organizations Act 2013. The CSO Reference Group, IRCK, and the NGO Council are perturbed by a statement released by the NGO Coordination Board to the media to the effect that jointly with the Ministry of Devolution and Planning, the board has submitted proposed amendments to the PBOAct to the National Assembly. Equally disturbing is a claim in the statement that the task force on the proposed amendments to the PBOAct recommended that the law be amended before its operationalization. We wish to state that the overarching recommendation of the task force, as indeed the overwhelming views collected from stakeholders and the general public, is that the 2013 Act be implemented without any further delay, considering that it was debated, approved, and enacted into law by retired President His Excellency Mwai Kibaki on January 14, 2013. Indeed, in all the public hearings that the task force conducted throughout the country, all presentations and memoranda submitted by the various stakeholders were unanimous that only immediate implementation of the Act will help consolidate the gains that Kenyans have made in the exercise of their constitutionally protected rights and freedoms of expression, association, and participation in the management of public affairs. In addition to having representation in the task force, the CSO Reference Group attended and documented on video and audio all its regional and stakeholder meetings, apart from a meeting with the members of the National Assembly. The CSO Reference Group has developed a shadow report based on this documentary evidence. The report demonstrates an overwhelming majority of Kenyans asking for the commencement of the Act without any amendments.
I'll take the next page of the statement. It is quite telling that while the NGOs Coordination Board went out of its way to enumerate some of the organizations that are represented in the Honorable Sophia Abdi task force on the proposed amendments to the PBOAct, the Executive Director of the NGO Coordination Board, Mr. Fazul Mohammed, found it convenient not to point out that he was the representative of the board in the task force as an interested party, and as such, he lost the moral ground to spearhead the implementation of the Act that has been unnecessarily delayed for more than 2 years. Those of you who are lucky to attend the public hearings organized by the task force, remember that the NGO Coordination Board was represented by none other than Fazul Mohammed himself. Unfortunately, he chose only to attend one sitting, and that indicates the level of irresponsibility on his part. One of the cardinal values and principles of governance articulated in Article 10 of the Constitution of Kenya 2010 that binds all state organs, including state and public officers, of who the Cabinet Secretary for Devolution and Planning, Honorable Anwar Iguru, and the NGOs Coordination Board Executive Director, Mr. Fazul Mohammed, are an integral part, is accountability. But despite the clarity of this constitutional ethos of governance, the Cabinet Secretary has once again chosen not to be guided by the obviously compelling right of the public, whose resources were spent on the task force to make the report public. That to date, the report of the task force on which public money was spent has not been made public, yet we are being told that recommendations have been submitted to the Attorney General and the Clerk of the National Assembly. And this has happened in complete and arrogant defiance of Article 35 on the right of the public and stakeholders to information. The CSO Reference Group, the Interreligious Council of Kenya, and the NGOs Council wish to point out that right from the time of their appointments, that is the Cabinet Secretary for Devolution and Planning and the Executive Director of the NGOs Coordination Board, have acted with such impunity against the civil society as though they are above the law, including the supreme law of the land, which is the Constitution. A case in point is the current obtaining situation at the NGO Coordination Board, where the term of all its directors, save for that of the Executive Director, expired in March. So as we speak today, the NGO Coordination Board has no directors, because all the terms of the directors expired in March. Yet Fazul Mohammed continues to purport to be speaking for a non-existent board. And you know that the law is very clear that any decisions affecting the public and public policy in particular has to be made by a board. And we find this quite unacceptable and a matter that can be challenged in court. And we say that in this statement that Mr. Fazul Mohammed owes the public an explanation as to who else other than himself sat in the board that is purported to have reviewed the task force report and its recommendations and forwarded the proposed amendments to the Attorney General and the Clerk of the National Assembly for inclusion in the so-called Miscellaneous Amendment Bill 2015. His eloquence when deregistering NGOs, as you will all remember, for not abiding by due process is not matched by due diligence when he purports to be executing decisions of a board that does not exist at all.
So in the foregoing, Fazul is acting unlawfully in what he's doing. It is the position of the Civil Society Organizations Reference Group, the Interreligious Council of Kenya, and the NGO Council, which has a numerical strength of over 750 civil society organizations in this country, that any decisions that the NGOs Coordination Board has made after the expiry of the term of the board, or in March 2015, including the alleged registration of some NGOs, are null and void, as it is only the board, when properly constituted, that is mandated by the law to make public policy decisions. The letter and spirit of the NGO Coordination Act of 1990 that established the NGO Coordination Board did not envisage the situation now at the board, where one man, Fazul Mohammed, sits with the secretariat and claims that whatever decisions is made at such staff meeting is a decision of the board. There cannot be a board without directors, and Fazul Mohammed should be aware that whatever decisions he claims to have made or to have been made by the board are challengeable in court. And when push comes to shove, we'll definitely move to court. We, the Civil Society Organizations Reference Group, the Interreligious Council of Kenya, and the NGOs Council, wish to reiterate our demand that the Cabinet Secretary for Devolution and Planning, Ms. Anne Waiguru, comes out of her self-constructed cocoon of impunity and make the report of the task force on the proposed amendments to the PBOAct public. It is only through the immediate commencement of the Public Benefits Organization Acts of 2013 without unwarranted state-instigated amendments that the civil society can consolidate the gains and deepen its cooperation and collaboration and respectful partnership with the government in serving the public. Immediate implementation of the law will also go a long way in unshackling the NGOs Coordination Board from the current shenanigans and the one-man show that it has become after the expiry of the term of the previous board of directors. Thank you. That's our statement.
There's a bigger problem than even the expiry, the fact that there is no board at that time. You all remember how Fazul Mohammed himself was appointed. The Constitution and its provisions on public service are very clear that there must be competitive bidding of those positions. You and I know that there is no single time in the period leading to Fazul's appointment when that position was advertised. Fazul Mohammed was unpicked because he was the only one idling in the corridors of the Ministry of Interior, and that's the only qualification that he has. So there are more things that we may want to move to court to question. Whether his appointment was done in accordance with the provision of the Constitution, he's heading a state corporation, a body corporate capable of being sued and chewing. Yet, whenever he issues statements, he does not even use the logo of the NGO Coordination Board. What does he do? Ministry of Planning, the presidency, to demonstrate his loyalty to those who appointed him. So he has basically compromised the integrity, the expected independence and autonomy of the NGO Coordination Board. So other than the fact that he has been making decisions purported to have been made by a non-existent board, we may also be moving to court to ask the court to nullify his appointment on grounds that it was not done in accordance with the provisions of the Constitution on Public Service. But as we have pointed out in the statement, you all remember that between March and now, Fazul Mohammed has been sitting in press conferences with staff claiming to be articulating positions of a non-existent board, including decisions to register, to deregister human rights organizations, Muhuri, Haki Africa, the Agency for Peace and Development, decisions that were never reached by any board. So when Fazul Mohammed deregisters organizations on grounds that they did not comply with the due process, I don't know what due process means to him, yet his own appointment did not follow the due process that is articulated in the Constitution. And these are the illegalities that we are going to challenge, irrespective of whether his benefactors, those who appointed him because he's a mercenary, a gun for hire, to frustrate civil society, that notwithstanding, I think the next course of action will be one, to go to court and ask the court to compel the Cabinet Secretary for Devolution and Planning to make the report of the task force public. That is like to be one of our prayers. Prayer number 2, to ask the court to nullify the supposed appointment of Fazul Mohammed as the executive director of the NGO Coordination Board without following the constitutional provisions on public appointments. 2, to ask the court to offer its advisory on the unnecessary delays for more than 2 years of the non-implementation of the Public Benefits Organizations Act, a law that was assented into by none other than the retired President Mwai Kibaki on the 14th of January 2013. I think this is the only law in the history, in the legislative history of Kenya, that has taken so long to be implemented. In the meantime, government is busy bashing the civil society for not complying with good governance, for not complying with reporting. Yet the law that is supposed to address that is held in abeyance. And these are some of the issues that we are thinking of moving to court to contest and ask that the Cabinet Secretary under which the civil society falls be held liable, be compelled, because she's under the rule of law, she's not above the law, to act and do the administrative thing of gazetting a commencement date for the PBOAct. Of course, we have issued this ultimatum. We will be expecting that if they are responsive enough, if they are aware that they were appointed under Article 35 of the Constitution on our right to information, if they make the task force report public, there might be no need to go to court. So our going to court will be determined by the responsiveness of the 2 actors that are acting against the provisions of the Constitution and the relevant laws.